All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And our first case this morning is People of the State of Michigan versus Robert Appleford. It's file 24-6930FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
Defense Attorney Sodium Paniente representing Mr. Robert Appleford, who's seated to my right.
Okay, good morning. We were here last time for sentencing, but then there was a show cause for an allegation of violation of bond conditions. So we adjourned the sentencing so that we could deal with that. So Mr. Paniente, do you know how your client wishes to proceed on that alleged violation?
Yes, Your Honor. If I may remain seated.
Yes, that's fine.
Thank you. Mr. Appleford will be admitting the violation.
Okay, Mr. Appleford, if you please stand and raise your right hand as best you can for me. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay, you can be seated, Mr. Appleford. Mr. Appleford, has anybody promised you anything in exchange for your admission to violating bond pay?
No, Your Honor.
Has anybody threatened you to make you do so?
No, Your Honor.
Is it your own free choice to do so?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the allegation of contempt of court, guilty or not guilty?
Guilty.
So, Mr. Appleford, as a condition of your bond, were you not to have any contact with the complaining witness in this matter?
Yes, Your Honor.
And did you have some contact with her?
Yes, Your Honor.
And you were also not to use or possess any alcohol at all?
Yes, Your Honor.
And did you consume some alcohol while you were on bond?
Yes, Your Honor.
All right, Mr. Paniente, you satisfied with that factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes.
All right, well, Mr. Appleford, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis, in fact, in law to believe that you have violated your bond. So I do find you in contempt. And so then we can move into the contempt sentencing and also the underlying sentencing then. So Mr. Paniente, have you had a chance to review the pre-sentence report and recommendations with your client?
I have, Your Honor.
Looks like we would need to make one correction to the jail credit. I think it was 2 weeks ago that I remanded him, so that'd be another 14 days of credit. Does that sound right to you, Mr. Paniente?
Yes, Your Honor.
Ms. Goodrich?
Yes.
Okay, so Mr. Paniente, do you have any additional additions, modifications, or corrections to the pre-sentence report?
I do, Your Honor. I have had an opportunity to review further the statutory maximum issue in this case.
Yes.
And I would put an objection and note that I think the statutory maximum should be 20 months on the PSI. The basis for that is People versus Loveday, 390 Mich 711.
You mean 30 months, right?
People versus Loveday, 390 Mich 711, 1973.
No, you mean 30 months instead of 20 months, right?
Oh, yes, I apologize. Yes.
The attempt statute is the 750.92, right?
Correct. And People versus Loveday specifically analyzes section 3, the semicolon in section 3, which is at the end of the sentence, last sentence, a semicolon. But in no case shall the imprisonment exceed half of the greatest punishment, which might have been inflicted if the offense so attempted had been committed. In full disclosure, in many places that I practice, that's just done as a matter of course, and I haven't necessarily figured out why that is. I have had an opportunity to review that a bit further. And I found this particular case, People versus Loveday, where the argument noted was that limitation in the semicolon in subsection 3 applies to 1, 2, and 3, to everything preceding it. And the argument was that the defendant claimed that limitation found in that paragraph applies to the entire statute. And the Supreme Court agreed and found that 1/2 is the maximum sentence when it's an attempt. And specifically, they referenced a much older case, People versus O'Neill versus the People, That's how old it is. The V's are, you used to do it the old way. That's from 1867.
Can you give me the Loveday site again?
Yes, Your Honor. Loveday, Loveday.
Just the site.
Yes, 390, Mich, 711, 1973.
Ms. Goodrich, do you have a position on it?
Your Honor, I was not familiar with this case prior to.
Yeah, in People v. Loveday, it seems that that was not the prosecution was not contesting the defendant's interpretation of that statute, so that really wasn't the issue. The issue was the prosecutor was saying that it was an attempt to procure fit under the principal offense of the gross indecency, and it wasn't an attempt at gross indecency. So I think when a point of law is assumed to be true, but it isn't a contested point, I think that's not that would be dicta at most. And I think it's flatly contradicted by the structure of the statute, which has, different situations. One, if an offense is punishable with death, then it's a 10-year felony. 2, if it's punishable by life or 5 years or more, then it's a 5-year felony. And if it's less than 5 years, then it's a misdemeanor, punishable by not more than 2 years, but in no case shall it exceed 1/2. So I think that is contained in paragraph 3. It's not contained in paragraph 2. So I think I'm required to follow the binding language of the statute, not the non-binding dicta from a case that I think improperly interpreted that statute. So I'll leave it at 5 years. All right, any other additions, corrections?
I would also add, Your Honor, that they adopt the position in O'Neill versus People from 1867.
I heard that. I made my ruling. Okay,
Understood.
any other
Thank you.
additions or corrections?
No additions or corrections.
Okay. The advisory guidelines were scored at 0 to 17 months. Any scoring challenges?
None from the defense.
Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
All right, Mr. Penante, any allocution you wish to make on behalf of your client?
Yes, Your Honor. Your Honor, Mr. Appleford, I'll draw the court's attention to part of the PSI, which notes his familial upbringing. And I'm not a psychiatrist, a specialist of that nature. I don't purport myself to be, just that I work in the legal profession and I sometimes deal with psychiatrists and see people, and I ask myself for the patterns of their behavior and how someone comes to the point where they are in their life, where they're standing before a court, like Mr. Appleford is doing so here. And at least from the pre-sentence investigation report, what I can see is that Mr. Appleford had a bad familial upbringing, one where his father abused his family, where he was one that he received that punishment himself, physical punishment. And ultimately, Mr. Appleford would note that partially he blamed his mother for not protecting him or his family. The PSI also notes that he eventually moved to live with a maternal aunt, Mary C.S. The reason I draw the court's attention to that, it is often, as the court's aware, the case that those who suffer abuse in themselves later in life end up being abusers. That is, I would report why Mr. Appleford has come before the court on the domestic violence verdict. That's not an excuse. Ultimately, there is no excuse because Mr. Appleford makes his decisions and his choices himself. He understands that. He's taking responsibility for that. And he's here today before the court because of that. Additionally, I would point out that Mr. Appleford is a veteran of our armed forces, the National Guard, that he was honorably discharged from that, and that his life greatly changed many
Defense
years.
counsel highlights Robert Appleford's rough childhood and abusive upbringing. trying to show how cycles of violence can repeat. He also points out Appleford's military service and prior successful parole, arguing probation with supervision might better protect the victim than a long jail term. But with multiple bond violations and repeated domestic assaults on the same partner, the defense is really asking the judge for one last chance. Should someone with such a long record still get the benefit of probation?
Many years ago, when he was far younger, when he was convicted of criminal sexual conduct. And that is the main reason for his high PRVs is that prior case and cases that happened afterwards within that gap. He successfully completed his parole and he was discharged from that. It wasn't easy, but he successfully did it. What that should tell the court is that he has the capability and means to be successful on probation. I understand the recommendation. There's also the safety of the victim to keep in mind, which if Mr. Appleford were put on probation versus with a term of jail, the court can then monitor his behavior and ensure that the parties and specifically the victim is kept safe. Additionally, the court is aware of the parties' contentious divorce. It is what it is. These things generally don't happen in a vacuum. Couples argue, and in Mr. Appleford's case, that argument came to violence, and he understands that. He bears the burden for his own decisions, Your Honor, and he asks that the court sentence him to a term of jail with probation. Thank you.
Thank you, Mr. Appleford. Is there anything you want to tell me today or no? You don't have to make a statement.
No,
but you're
Your
allowed
Honor,
to.
just that I'm embarrassed to be almost 59 years old, and once again, Your Honor, I'm standing in front of you. I apologize, but I accept the punishment as it is.
All right, thanks, sir. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. The defendant is 58 years old. He has 5 felonies and 7 misdemeanors. What is significant is when reviewing his criminal history, it involves sexual assault, animal cruelty, assault, domestic assault, and larceny in a building. So it's largely victim-based. There have been more than one bond violation of contacting the victim in this case. He was given a second chance by the court, but then continued contact thereafter, which led to his current status and incarceration. And I think also voids the sentencing agreement that was outlined at the time of plea taking. At this time, I would ask that the court order 12 months jail. If the court does order any probation, the victim does wish to continue the no contact order. Thank you.
Thank you, Mr. Appleford. If you please stand for the court sentence. Mr. Appleford stands convicted of attempted domestic violence third. And there was a sentence agreement for sentencing on the low end of the guidelines, but his post plea violations and contempt nullify that. And, you know, I understand with some of the contact violations that you were not the only person participating in that contact. It wasn't always completely unwanted contact. I understand that, which is why then the first time your bond wasn't revoked. But then knowing that you continued on that path, and that was a really poor decision. But also then I note that, you know, you've got repeat domestic violence on the same victim. You know, contentious divorce certainly is no reason for that. Your first assault conviction was in 1991. Then you were convicted of a CSC in 1993 and given about 20 years in prison. You were paroled and discharged in 2013. And then in 2016, you got a domestic assault, 2019, a domestic assault, 2020, an animal cruelty, 2024, an impaired. And while you're on probation for the impaired, you get this case. While you're on bond for the impaired and you get this case. And I got to tell you too, if you were convicted as charged with the habitual fourth, that would be probably a prison sentence. And I don't want to get into the details, but you've now got financial reasons why you don't want to go to prison, because they will take that. if people go to prison that have means, the Attorney General will seize it to pay for the imprisonment. So apparently being sentenced by judges over the years, placed on probation or parole, or locked up has not been enough motivation to get you to stop appearing in front of judges. So I'm
The
trying to
judge delivers the final blow, 12 months in county jail for attempted domestic violence, plus 93 days for contempt served at the same time. Appleford's criminal history reads like a pattern: sexual assault, animal cruelty, impaired driving, and repeat domestic violence. The judge even warns him if he ever lands in prison again, the state could seize his finances. After decades of second chances, the court seems to have lost patience. Do you think this one-year sentence is enough to protect the victim and the public?
So I'm trying to give you maybe another motivation, that if you end up in prison again, you can kiss those means goodbye. So maybe that will help give you one more reason to check yourself before you cross those lines. But you do have a really significant criminal history and a fairly significant assaultive history, and here to the same victim over a period of time as well. The advisory guidelines are 0 to 17 months. I think given what I've outlined, there are reasonable grounds for incarceration. So I am going to order you to pay a crime victims assessment of $130, court costs of $350, state cost of $68, and I'll order you serve 12 months in the Sheboygan County Jail and give you credit for 21 days previously served. We're not going to impose any probationary sentence. On the contempt, it'll be 93 days jail, credit for 14 served. Those will run concurrent. And you can file an application for leave to appeal if you wish to the Court of Appeals, if you want a lawyer, and if you qualified, which I'm not sure you would now, but if you qualified, we'd appoint one for you, but you'd have to make that request within 6 months. We're going to hand that appeal paperwork to you and ask you to initial one copy for us. The other one's for you to fill out if you wish to take an appeal. All right, good luck to you, Mr. Apple.
Your Honor, would I be mailed a copy of the judgment of sentence, or
Yes, sir.
should I request that?
Yeah, we'll send one to counsel of records.
Thank you.
Go off the record of being recessed till 10.